Article 56A of the Maltese Gaming Act and the challenge to enforce foreign judgments in Malta.
Good morning, everyone. This panel will be discussing Article 56A of the Gaming Act, a new piece of legislation that was introduced in Maltese law mid-2023. Many of you might be familiar with its previous name, Bill 55. We discussed it at Sigma last year and on a number of panels in other conferences. So this particular piece of legislation has sparked considerable debate, particularly concerning its compliance with EU law and its impact on the gaming industry across different jurisdictions. Why, you may ask? So basically, by introducing this article in the Gaming Act, the government basically introduced a sort of blanket provision where Maltese licensed operators would be protected from having judgments from other EU jurisdictions enforced against them in Malta. And as you can imagine, this is quite controversial, especially across the EU, where we have the Brussels recast regulation, which requires EU countries to recognize and automatically enforce judgments in the different jurisdictions. So I have here with me today lawyers from Germany and Austria. Over the past 2 years, I've had the pleasure of working with our Austrian lawyer on the panel, Nicholas Aquilina from BRANDL and TALOS, because we have been, let's say, combating the enforcement of hundreds of judgments from Austrian players who had obtained judgments in Austria, which were awarding them a refund of their gambling losses. With those judgments, in terms of EU law, these players have sought to enforce them in Malta against Maltese licensed operators. And as part of our defense, we have raised a number of arguments here. But what I'd like Nicholas to tell the audience today is how this particular piece of legislation has affected the claims in Austria, because we know that in Malta the matter is still not resolved, so we can't really give any indication where this is going to go. We know where we want it to go, but not quite where it's going to go. So, Nicholas, could you please share your experience with us?
Sure, thanks, Davinia, and good morning, everyone. So I think you actually need to just quickly go one step back when discussing this topic. The claims, Davinia, that you are talking about are obviously all financed by commercial third-party litigation funders, commercial companies funding these claims. So obviously, for their return on investment, the shortest possible time from making a claim to cash is key, right? That is their key objective. So in my view, there have been 3 results that Bill 55 has had on the situation around player claims in Austria. Number 1, it has had a deterrent effect on these claims overall, because obviously the time from bringing a claim to actually receiving cash has become a lot longer. Number 2, we are seeing alternative business models come up, like for instance, funders who are buying the claims off of the players, of the plaintiffs, and then pursuing those claims, those assigned claims in their own name. That's something that my German colleagues will probably also be touching on, because it's something we're seeing there as well. And of course, the funds that they are using to pay the players to buy those claims off of them are a lot lower than what they would usually be getting, what the players would usually be getting. And the third effect that this has probably had is, simply that the litigation funders and also the lawyers who are working for these litigation funders have become a lot more creative in their approach towards the market. It is a market for them, obviously. So that ranges from claims that have been filed against holding companies, claims that have been filed against other legal entities that are involved in the operation but are not the actual operating entity, and obviously also what we have seen and what we're currently also pursuing to the ECJ in a case is claims against directors of operating entities. So yeah, simply to exert further pressure on the operators.
At the beginning, you said that it has had a deterrent effect. I can actually confirm that from our end in Malta, we have seen a slowdown in the number of cases being enforced. So our experience is exactly the same here.
And it is because everyone is obviously, as you said, now looking towards Malta and how obviously the, how things will develop over here with the multiple cases that are now pending in court from an enforcement point of view.
And some have been pending for 2 years now, whereas in theory they should have been automatically enforceable. So I suppose even the fact that they would have had this experience would have contributed to the deterrent effect. Claus from Germany, so our last two panelists to my left are both lawyers from Germany. Claus, with your, Joerg, not Claus, from a regulatory perspective, Joerg, how has Article 56A of the Maltese Gaming Act affected the sector in Germany? And are there any differences in the legal assessment of sports betting and casino games? How do they tie in?
Yeah, the impact of Article 56A was massive and overnight, because the German enforcement proceedings and regulations overnight faced an international impact. Usually, if a plaintiff wins a case, he can, of course, ask the defendant to pay. If he doesn't pay, there is enforcement. The bailiff will show up and he will get his money as long as the defendant has the money which he has to pay. Now it's different. Now you cannot enforce just because there are two national, two domestic regulations, jurisdictions conflicting with each other. And that is not only a cross-border international relation, that's also becoming a European Union legal background. And insofar it's important because the relevant question is the law in Malta justifiable? Is it valid? Can it be applied? And you mentioned Brussels recast. The Article 45 is Brussels recast, says generally enforcement is possible among the members in the member states, but it also says something which you can copy and paste, seen in Article 56A. It says, under some circumstances, if this is not in line with the public policy, the ordre public in a member state, the member state can refuse to accept enforcement of such decisions. And we are talking about decisions of German and Austrian courts, where the legal reason for the decision, if it's in favor to the player, simply is the Maltese license is not valid and the internet gaming ban in Germany is compliant or valid or whatever, and the underlying agreements, Claus will elaborate this further, are null and void, so they'll have to pay back. Whereas Malta says, we have licenses legally granted to our operators. So this is a conflict which is decisive. Malta cannot accept that a German court takes the view that the Maltese license is not legal. If a Maltese court would accept this point of view, then it would indirectly rule out that the Maltese license system is not applicable, is not void, is not valid, and that is a no-go. It's a matter of public policy. This is where we are. At some point, maybe the European Court of Justice will have the final say on this. It will also have to rule out whether the German interdiction regulation, the internet bans, are compliant with higher-ranking European Union law. We're talking about the freedom of services, and there are good arguments to question this. And that's why I can build the bridge to your second question. Is there a difference between sports betting and casino games? Yes, there's a big one. I wouldn't say legally, but I would say practically, because in Germany there was a tender in 2012 for sports betting operators. 20 sports betting licenses were to be granted to operators by way of a tender. This proceeding, this application proceeding, collapsed completely by litigation. It was the European Court of Justice ruling out that the German sports betting regulation and the tender in particular was not in line with European Union law. It was not transparent, not coherent, and so the administrative interdictions, the criminal sanctions were not applicable. Same jurisprudence we saw with German administrative courts even earlier. From that minute on, there was the criticism saying there is a de facto monopoly in sports betting because the German state offered sports betting and was not able to provide a valid licensing regime and system until 2020. And that's why courts takes the view, I would say the majority of courts can be convinced that this is a different story. It's more or less kind of a de facto toleration of these offerings. So the chances to win these cases against the player claims are much higher. For casino games, we don't have such ruling. We don't have such ruling on the European level. And I must say, the situation is almost similar because Germany is running casinos, land-based casinos. Germany is doing arcade games in these days. But not online. Online is just another channel of distribution, so maybe there are similar arguments, but so far they haven't been raised. We can say that casino games and the corresponding claims of players, the majority of these claims, the courts rule out in favor of the players. So that makes it a real threat to the industry. But for the time being, many cases are suspended because the Federal Civil Court suspended a case and transferred it to the European Court of Justice in July this year. And we will see what the outcome of this jurisprudence is. So we can expect a final saying of the highest European court on this, which will then be referred to the German courts, and they have to apply the assessment of the ECJ. For now, I think that's my summary.
Thank you very much. Claus, so Article 56A refers specifically to a principle of public policy. So it starts with as a principle of public policy and then continues to give the protection that I described in 20 seconds when we started this panel. Can you explain how it is being challenged in Germany in German courts?
Yes, thank you. In Germany, there hasn't been yet a direct challenge of 56A yet. The reason is because it's a clear Maltese enforcement law, which does not directly impact Germany in the first place. So players would try to either enforce in Germany, but usually there aren't any assets, so they have to go to Malta to enforce. But there have been indirect challenges of the 56A. One of them is player lawyers have approached the Department of Justice, who contacted the EU Commission to look into the legality of this law, the Bill 55 back then, and to investigate. Currently, the Commission is investigating. It might take years. They have different ways to act. They could start infringement proceeding. They could go to the ECJ, but this will all take time, quite some time. So, but as you just explained for Austria, it's the same in Germany. They need money, they need fast money, so they are using and looking for other opportunities to speed up the cash flow back, so to say. And so the second approach they have used was to approach the Gambling Supervision Authority in Germany, the GGL, and they tried to put pressure on them to even revoke licenses for German licensed operators if they do not pay on the judgments. The argument is, okay, if you do not pay on enforceable judgments, you're not reliable. So this way they want to put pressure on the GGL to revoke licenses, but to our knowledge so far, we had a case where this was tried. There was a very clear statement from the GGL. We are not an enforcement body. We are the Gaming Supervision Authority. So they clearly rejected such a request to look into the reliability of the operator. So this was a very important signal from the GGL to reject such wishes, so to say, to take pressure on the Bill 55 or 56A now.
I'm curious, can there be an appeal from this decision?
No, not for this such
No,
a decision.
so it's fine
it's
at
just
this stage.
It's a question of competence, and they
Right.
clearly reject it because we are not competent. We're not an enforcement body for civil law cases. We have a special officers who are responsible to enforce, but this is not the Gambling Supervision Authority. So this path is clearly not working, what they have tried. So they tried to find a way via the Commission, ECJ. They would try to create cases, to bring cases to the ECJ, even if it doesn't have anything to do with Austrian or German laws. But they would try to find a shortcut or make up cases to try to deal with it and to speed things up.
Nicholas, are you seeing the same in Austria?
Well, it's very comparable, maybe with the one nuance that in Austria, at least for online casino, there is no regulator as such because there is a monopoly, and the operators who are active in Austria are basically challenging that monopoly and defending their presence in the Austrian market on the basis of the EU market freedoms and the monopoly not being in line with the market freedom. So there is no regulator as such that would be taking action on the basis of lacking suitability. There are obviously sports betting operators because, like in Germany, the products are regulated differently, but sports betting in Austria is regulated in a very liberal way, but also there, so far we haven't seen any of the local regulators raise any suitability issues with regard to Bill 55. Obviously, you always have to keep in mind that having a final and binding judgment from either Austria or Germany against you is one thing, but the enforcement is obviously a totally different topic, totally different. And for that very reason, there is also a second set of rules that applies to the enforcement procedure. It is simply a different type of proceedings. Apart from that, what we are obviously seeing is the same pressure, Claus, that you have mentioned that has been exerted, let's say, on the political level, that goes into the EU Commission and goes into Brussels. That is one thing. And then, I would assume that we will be seeing more challenges coming from the side of the litigation funders over the next coming months to try and, challenge the Ordre Public blocker that Malta has put in place here.
I think ultimately the fact that the same regulation that requires countries to recognize judgments itself worked in the public policy defense, and the fact that Malta replicated that in the Gaming Act, clearly stating that this was a principle of Maltese public policy, should place Malta in a good position to defend the stance it's taken in this regard. Well, our time is up. Thank you very much for being with us today and for sharing your knowledge and experience.
Thank you very much.